Oh,
Lord, by this bench, my Lord, this matter was directed to appear as to be mentioned today. This is the order. You also can see the order.
শোনো, এটা ওই আমাদের যেটা স্পেশাল বেঞ্চ হয় সেখানে থাকে। আজকে তুমি একটা সাপ্লিমেন্টারি লিস্ট করে দিতে পারবে? আমাদের 3:30 স্পেশাল বেঞ্চ তো নেই কিছু আছে। ছিল তো একটা স্পেশাল বেঞ্চ আজকে ওনারা আমার। হ্যাঁ হ্যাঁ সেটা একটু there's a little bit of confusion because of the regular bench not being
Yes,
there.
sir.
Next week, when the special bench sits, it will be listed as to be mentioned. We can't tell you which day, but it will be listed next week. সামনের সপ্তাহে দেবে একটা
Yes.
করে দেবে।
May be permitted, Lordship. One matter is appearing in the list and not last Tuesday, this bench, my lord. Since this bench is further, my lord, sitting, I am drawing Lordship attention with regard to a contempt application. I am not.
This bench will sit only till tomorrow.
My lord,
See the determination, look at the list,
yes,
it is
my lord.
mentioned there.
Yes, but we are suffering, my lord. We are not able to construct our, that is why first time contempt,
No, it can be listed tomorrow, but contempt of whose order?
my lord, order by this bench, my lord.
Give it.
First time since, my lord, that is why I am trying. Keep on.
May seek your indulgence, my lord. One matter, as item number 43 of the appellate side, my lord. This is for the first time the matter has appeared.
You are the appellant.
Yes, my lord.
Where the
We are
appellant?
not ready because of the reason, my lord.
Sir,
How
sir.
to say,
the matter has appeared
item number 43, my lord.
at our instance because you are not interested to proceed with the matter.
I am,
We had to
my,
find out the matter
I
from the
understand,
department.
my lord, that is, I'm just, kindly allow me to submit, my lord. The service has not yet complete, my lord, at one thing.
We'll dismiss the appeal, 22 appeal, not service not complete. On that ground, we'll
And one
dismiss the
thing
appeal.
also, the stay application has not been,
That is your problem.
after only after 1 week, kindly
22 appeals, sir.
next week, my lord.
And now we face the criticism that millions of matters are pending.
Oh, my lord. Kindly give an indulgence, my lord. Kindly allow,
This is the degree of seriousness you show.
right, my lord. I have serious, my lord, matter because I have some genuine grievances, my lord. Kindly after a week, only after a week, my lord, kindly allow 43 item.
On the prayer made on behalf of the appellant,
Huh.
hey, it appellate side.
In the meantime, I will serve and stay application will also be Fine, my lord.
On the prayer made on behalf of the appellant,
and the appellant.
let this matter stand adjourned for a week and be listed again on সামনের বৃহস্পতিবার করে দাও।
Lordship, if I may be permitted to mention one application for restoration. I have already served.
My lord,
Much of that.
my lord, may I be permitted to mention a matter, my lord? My lord, on 22nd March 2023, my lord has directed this particular matter to be tagged with other two matters, my lord. My lord, that is for the inclusion in the list, my lord.
Are you mentioning upon notice?
No, my lord.
Mention upon notice?
Can I have your lordship's kind leave to mention one matter? My lord, there are two appeals which have been released from Justice Haristandan's court. So hence filed in this court, my lord. I am just praying
What
for
do you
the.
mean hence filed in this court? Unless it is assigned, how can you file in this
Yes,
court?
yes, my lord. It's a assigned matters.
Assigned.
It's a assigned matters. I'm just praying for inclusion of the matter in the list.
What is the matter? See? Dekhi ki kagaz. Where is the assignment? I dekhe now. দেখে নাও যদি অ্যাসাইনমেন্ট থাকে দিয়ে দাও লিস্টে সোমবার দেবে
My lord, my learned senior friend who was there in the matter, my lord, he's present here, my lord.
Who is that?
My lord. My lord. My lord, this was a matter, my lord, which was supposed to be tagged with the along with the other two matters, my lord. According to my
How
lord.
do we know? Where is that order?
My lord, the order is already annexed here with my lord.
Oh, this is heritage.
Yes, my lord.
Heritage.
The heritage matter. Yes, it's pending to not matter. It profits. Finally, the matter.
Yes, yes.
The answer on that matter is not confronted with the two other matters also.
Very well. দেখো যেটা করতে হবে করে দাও
Obliged, my lord.
May I have your lordship's leave to mention, my lord, item number 64 of yesterday, my lord. It was dismissed for default, my lord.
Yesterday's list.
My lord.
Yes.
My lord, item number 58 and 64 both were dismissed for default, my lord. I communicated, my lord, but somehow due to some miscommunication, 64 was not struck off from dismissed for default.
We have not followed. Yesterday's 64, yesterday's list is not with us. How do we know which matter? কি হয়েছে? বলেনি একটা। So the one that you mentioned was not dismissed. We recall that order. The one which you didn't, we have signed the order. You have to file for restoration. Nothing can be done.
Yes, as your lordship pleases.
So I am for the appellant, your lordship. So we serve the your lordship the copies to the municipal corporation, your lordship is an appeal, your lordship is to the extent that the direction upon us, your lordship, to deposit 10 lakhs rupees with the Calcutta Municipal Corporation. May I just state the brief facts so that your lordship, I can place your lordship the impugned order. This matter, your lordship, is in.
Was this heard before by us?
Yes, your lordship. There was a direction by the honorable division bench directing them
Order
to decide two issues. Lordship, kindly come.
Order এর ফাইলটা দিতে বলো।
No, this matter, your lordship, I have
First time.
but regarding the same issue,
This is KK Shaha rings a bell.
KK Shah,
The earlier matter.
That's right.
You know, if the orders were in this case.
page 143.
It's a fresh case.
Fresh case.
It's a fresh case,
Right.
but your lordship, identical issues, your lordship has passed an order. Now, this matter, your lordship, is relating to the Hathibagan market regarding the garbage removal charges. Now, we moved before the honorable single judge. At that point of time, the honorable single judge directed us to deposit 27 lakhs rupees. We preferred an appeal before the honorable division bench. The honorable division bench framed two issues to be decided by the municipal commissioner. Once, where to be deposited and who is liable for payment of the garbage removal charges. The municipal commissioner
And the appeal was disposed of.
appeal was disposed of. Now, the municipal commissioner passed an order without considering those two issues. We filed a writ petition before the honorable single judge. Honorable single judge set aside the order. But again, your lordship directed me to pay 10 lakhs more. Because at that point of time, as per your lordship's order, we have already deposited 5 lakhs rupees. Now, this particular issue has not been decided who is liable to pay. But you kindly take once the honorable division bench order at page 143. Lordship, the effective portion, your lordship, is page 144. second paragraph.
Allow us to go through it. We,
Yes.
earlier writ petition is pending.
No, Lordship
didn't
has
also
disposed of the writ petition also.
We disposed of.
Yes, Your Lordship.
Gotcha. Then the order of the municipal commissioner.
Your Lordship, the order of the municipal commissioner. Your Lordship, page 184. Your Lordship, is the covering letter, page 185. That has been set aside by the Honorable
Oh,
Single.
that has been set aside.
Yes, to the extent,
Court directed us, my lord, once again, consider this, follow the question of violation of natural justice, basically, court will consider. And thereafter, you directed us to pass a fresh order in respect to, in terms of your lordship's decision is this.
correct.
10 lakhs, this time 10 lakhs. No.
This time, 10 lakhs, the issue has not been decided. I should kindly appreciate my situation. The entire market, Your Lordship, I can fetch.
As I understand, my lord, its grievance is, my lord, that because your lordship order has to be complied with, the earlier division bench order. The court thought in three, my lord, the two at least, but one issue has to be properly addressed. Second issue had to be decided, but he has some grievances with regard to the natural justice, my lord, because he did not turn up on the docket, but he made an objection after the order. That is the reason court, my lord, sent it back to ask, my lord, for fresh consideration. His basic grievance, as I follow, my lord, that the 10 lakhs would have directed, that is possibly, my lord, present grievance. Otherwise, my lord, the matter has to be addressed because the order of.
To the extent,
What do you say to that?
Only I am submitting because, my lord, after all, when the corporation has to, my lord, it's a private market, the garbage is, my lord, the accumulated, my lord, 350 my lord, metric ton per day is accumulated on a public street, it has to be removed. Now the thing is this, my lord, according to us, my lord, the estimated, the cost was assessed, my lord, more than 71 lakhs. Maybe my land has the contention that it might not be, my lord, so much of amount, it must be reduced or less. You know, directed that 5 lakhs, then you put the directed that 10 lakhs more.
Mr. Shengupto, the last order of the division bench was September 2022.
Lordship.
I'm actually very happy that I remembered the name after 9 months. KK Shah.
Only one market, Your Lordship, actually, we are otherwise all markets have
Right,
gone.
right. Some amount you have to pay, show your bona fides.
Lordship, on the
We'll
last,
reduce the amount. We'll reduce the amount.
Lordship, on the last occasion also I have paid. Now the thing is,
Yes, you paid 5 lakhs in September. Now 9 months have passed by. Garbage has accumulated, no doubt.
Lordship, only appreciate one situation, Your Lordship. I'm not bargaining, Your
Don't
Lordship.
bargain. It is very hot outside.
Lordship, kindly appreciate the situation, Your Lordship. This Hathibagan market, 900 tenants, they give Your Lordship 20 rupees, 30 rupees rent. Kindly appreciate the situation. They are not charging from the occupiers, which they can do it. Act says you can go and catch the occupiers.
Mr. Shengupta,
1 rupees, 2 rupees, they can always collect.
we do not know whether 100 rupees or 150 rupees what you are getting. That is nothing on record.
I can
Nothing on
produce Your
record.
Lordship. I can produce Your Lordship, knows Your Lordship, this market, Your Lordship, 900.
Next report, we'll reduce the amount. And how soon can you decide the issue?
1 month more per time because
1 month more time.
The reason they have given me everything, their own department could not, your lordship, find out the gadgets from where you
Very
lordship
well.
is charging.
They'll give you a hearing, they'll do everything. We'll reduce this amount. For the time being, pay 3 lakhs more. 3 lakhs.
Sir, parbe na, sir. Sir, parbe na.
Too much of garbage.
50%, 50%, very well.
Kindly, your lordship, kindly don't, your lordship, in
50%. He also. My sister also says so.
your lordship 25.
No, no. Yes, Esho. আরে দাঁড়াও ভাই আমি তো অর্ডারটাই পড়ি নিয়ে পড়ে নিয়ে
I've challenged to the extent, your lordship. I've written, your lordship, in the memo of appeal.
আচ্ছা
এই স্বাতি সাথী বলে তো ওকে পাঠিয়েছে বলে তো দেখেছি দিয়েছি হয়েছে এখন হয়েছে প্রিন্সিপাল কমিশনার হ্যাঁ প্রিন্সিপাল কমিশনার বলছে গেজেট চার্জ করছে সেগুলো আমরা দেয়
সেটা অর্ডার
The appellants, oblique writ petitioners, are the owners of what is popularly known as the Hatibagan market. Hatibagan market is single inverted comma. Stop. There are hundreds of shops being run from that market. Stop. The activities in that market result in garbage, in accumulation of garbage in the market premises. Stop. In an earlier round of litigation, paragraph 4, in an earlier round of litigation, comma, the appellant's hearing approached a learned single judge of this court by filing WPO 452 of 2020 with the grievance that the Kolkata Municipal Corporation, bracketed KMC, was not collecting the garbage that resulted from the activities in the market premises, but was insisting that the garbage should be deposited at a particular place from where KMC will collect the same. Stop. The writ petitioners argued that this is not what is envisaged by the KMC Act, 1980. Stop. The learned single judge had called for a report from KMC indicating the charges that the writ petitioners were liable to pay for removal of garbage. Stop. Such report indicated that a sum of rupees 27.77 lakh approximately was due from the writ petition.
Just clarified in the subsequent order, it's a part of the claim. Just
Part,
the
part.
entire claim. Because it is lordship clarified in the subsequent order.
From writ petitioners due from the writ petitioners to KMC for the period 2016 till August 2022. Stop. The learned judge directed the writ petitioners to pay a sum of rupees 15 lakh within a fortnight from the date of the order and the balance within a fortnight thereafter. Stop. Being aggrieved, comma, the writ petitioners prefer an appeal, being APOT 164 of 2022. Paragraph. The appeal and the connected application were disposed of by a coordinate bench with the following observations and directions. Page 144 থেকে set out. Paragraph.
That clarification was made by in that page number 46 order, 146 order, 140, actually 146. Part of the
The aforesaid order was clarified by a subsequent order dated September 21, 2022. এই আগের অর্ডারটা ডেট দিয়েছিলাম যেটা এখন তো যেটা সেট আউট করতে বললাম তাদের তো দিতে হবে কি বলেছি বলো দি said appeal was disposed of by a judgment and order dated September 15, 2022, with the following observations and directions. With the following, next, the aforesaid order was clarified by a subsequent order dated September 21, 2022, by recording the submission of KMC that the amount of rupees 27.77 lakh was only part of its claim against the appellants. Next, pursuant to the aforesaid orders of the revision bench, the municipal commissioner, that is at page
Your Lordship, Municipal Commissioner's order, page 184.
passed an order
85.
dated January 20, 2023. So the operative portion of the said order reads as follows. Page 185 থেকে ঠিক আছে Paragraph. Being aggrieved, the appellants herein challenge the aforesaid order before the learned single judge in the present round of litigation by filing WPO 794 of 2023. Paragraph. The learned judge noted that, firstly, the written objection of the appellants to the preliminary assessment of the garbage collection charge was not considered by the municipal commissioner. Secondly, the issue as regards from where the garbage was to be collected by KMC was not decided or even adverted to by the municipal commissioner, although that was one of the issues which he was required to address as per the division bench order dated
15 September 2022.
dated
15 September 2022.
September 15, 2022. Learned judge finally noted that for whatever reason, the appellants could not be present at the hearing before the municipal commissioner. The learned judge opined that for the ends of justice, a further opportunity of hearing should be granted to the appellants. The learned judge set aside the order of the municipal commissioner dated January 20, 2023. So the operative portion of the order of the learned judge, which is assailed before us reads as follows. A memo থেকে দিয়ে দিও, memo থেকে internal page 3. Paragraph. Being aggrieved by the portion of the order directing the writ petitioners to deposit rupees 10 lakh with KMC within a fortnight from the date of communication of the order. The order was passed in your presence.
Yes, your lordship, but
Fortnight from date of communication to whom?
to the municipal commissioner, your lordship.
ওটা বলতে হবে না, rupees 10 lakh with KMC. Stop. Learned advocate for the appellants says that the commissioner is yet to finally decide the issues framed by the division bench by its order dated September 15, 2022, passed in the earlier round of litigation. Stop. In terms of that order, the appellants have already deposited rupees 10 lakh,
5 lakhs.
5 lakh with KMC. Stop. The tenants at the Hatibagan market pay an absurdly paltry rent and pay absurdly paltry rents to the owners of the market. Stop. It would be a very heavy burden on the owners if they are required to deposit rupees 10 lakh towards garbage collection charges even before that issue is finally decided by the municipal commissioner. Paragraph. Mr. Ghosh, learned senior counsel representing KMC, says that it cannot be disputed that some amount is payable by the appellants to KMC on account of garbage collection charges. Stop. As recorded in the orders passed in the earlier round of litigation, part of such claim of KMC is in the region of rupees 27 lakh. Stop. The municipal commissioner had assessed the claim at a sum of approximately rupees 61 lakh. Stop. Although such order of the commissioner has been set aside, nobody can dispute that an appreciable amount is payable by the appellants to KMC. Stop. The appellants deposited only rupees 5 lakh in September, 2022, pursuant to the order of the division bench. Stop. About 9 months have elapsed since then. Stop. Further sums have become due on account of garbage collection charges. Stop. Rupees 10 lakh is a reasonable figure. 10 lakh or 15? What did the learned judge say?
10 lakhs, your lordship.
Is a reasonable figure according to Mr. Ghosh. Paragraph. Having considered the rival contentions of the parties, we are of the view that some amount definitely should be paid by the appellants to KMC immediately. Stop. However, since the municipal commissioner has not yet finally decided the total dues of KMC from the appellants on account of garbage collection charges, ends of justice will be served if the appellants make an immediate deposit of rupees 5 lakh with the KMC. Stop. Such deposit is to be made within a period of a fortnight. 3 weeks. 3 weeks. 3 weeks from date. Stop. Needless to say that the municipal commissioner shall pass fresh order after giving reasonable opportunity of it.
Yes, these for points before us in writing. If he, my lord, wants to make, my lord, any further, my lord, written notes to us, my lord, he can do it, my lord, within a certain time. And we'll, my lord, pass an affidavit order, my lord, on consideration of that.
No, he has been granted.
So
Hearing was
once
given, my lord.
one hearing has been granted, they failed to give the budgets.
No,
because-
that budget, my lord, whatever the budget, let him put his case before us. Then whatever the
We have-
charges, we will, my lord, in our
As per-
my lord, order, we'll put it.
Lordship, as per your lordship's direction, we have given a comprehensive representation.
Mr. Ghosh,
He has been asked to
That's
make a comprehensive representation.
I've done it, I've given it.
given it that
Well, he has given it, therefore, my lord, if any other points he has to raise, my lord, let him, my lord, raise. And we will pass an order, my lord, giving reasons, sir. about that.
additional representation file that
Will-
we'll say,
will give.
কি বললাম না needless কেটে দাও এটা প্যারাগ্রাফ করো KMC Mr. Ghosh representing KMC says that the appellants have already filed a comprehensive written representation before the commissioner. Stop. One hearing was also granted to them. Stop. If the appellants want to urge any further point before the commissioner, the same may be done by way of additional written representation. Stop. We grant liberty to the appellants to file such additional written representation within
Within
a fortnight from date. Stop. The municipal commissioner, it is desirable that the municipal commissioner disposes of the matter and passes a fresh order within how much time the learned judge has said?
2 months were done.
It's already expired, your lordship.
Yes, right, you will make another.
Within a month from the date of receipt of the additional representation.
6 weeks, then well, it becomes 2 months from now. If he, my lord, makes him, my lord, within fortnight, if he does grants us from the date of receipt, my lord, 6 weeks, my lord,
Very
it
well.
becomes 2 months.
Within 6 weeks from the date of receipt of the additional written representation from the appellants, in accordance with law. Paragraph, the order impugned in this appeal is modified to the aforesaid extent. That's all.
To make the deposit, because, my lord,
Deposit we have said.
right, you know, say, my lord, within 3 weeks, let him deposit that, but he cannot delay the matter, my lord, for regarding the deposit of that.
First decide it tomorrow. Decide it tomorrow, matter ends.
I think we have not called for affidavits, etc., etc.
So only one thing, your lordship, the acceptance and payment both would be without prejudice, your
Yes,
lordship.
of course. ওই যেখানটা ডিপোজিটটা বলেছি ওখানটা such deposit shall be made by the appellants and shall be accepted by KMC without prejudice to the rights and contentions of the respective parties.
So only one thing, your lordship, if your lordship,
This
subject
is
to
the second thing. One, yes,
if the tenant association should also be present at the time of hearing.
That is not
On
necessary.
the last occasion, your lordship clarified
but
it.
hearing is already over, Mr.
That
Shenko.
is not necessary.
No, notice has been given, they are not appearing, they are the main person. If they agree, every problem will be sorted out.
How can we direct the association? They are not even parties.
They are parties, your lordship, but. they are not appearing.
Maybe. You persuade them to go
Yeah, I'm grateful, your lordship.
dispose of, huh?
I'm grateful, your lordship.
For the appellant, my lord, in this matter.
Yes,
Appellant, my lord.
why has this been
I don't know, my.
to be mentioned?
I do not know, it was, my lord, regularly, it was, my lord, the application, your lordship had decided on the last occasion by an order that the appeal to be heard on the application itself. That was possibly recorded in your lordship's order.
My.
And, my lord, to be mentioned, I do not know, my lord, why it has.
You also don't know.
No, no,
You are
no.
the appellant.
I am for the appellant. my
You
lord.
don't know, KMC doesn't know.
Suddenly this matter.
কোনো ডিপার্টমেন্টাল নোট আছে দেখো ফাইলই নেই. Oh, somebody mentioned that some learned lawyer's name was not included in the order. Out of list.
Can I take it up in the next week, my lord?
What
Because-
take it up? Whatever order is there, earlier
No,
order.
1 week after vacation, this matter is due to appear.
Very big.
Can I take it up on next Monday or Tuesday as your lordship meeting?
ঠিক আছে, এটাকে দেখো তুমি তাহলে ইয়ে করো.
Yeah, as in hearing, my lord.
That one.
Under
No,
here.
no, hearing not. Under the heading application, under the heading application, my lord.
Yeah.
No, application issue. Application is last item.
অর্ডারটা আছে দাও তো একবার. Hearing.
May I assist your lordship, my lord?
This matter will appear at the last item in the application.
তো মহা মুশকিল. Oh, last item.
Yes, my
My lord,
lord.
may I assist your lordship, my lord?
Yes.
My lord, I am assisting Mr. Ghosh in this matter. My lord, lordship, on the earlier question, it was said on behalf of the appellant that the stay petition contains all the documents that were before the learned judge. So there is no need for preparation on a paper book. That is why they said that the main appeal could be heard. And lordship, my lord, said that the appeal itself will be heard. This was last order passed by your lordship.
To be listed under the heading application or hearing.
Last matter as application.
Last matter as application. That
Yes.
That was the lordship.
ফাইল নেই তোমার কাছে. Yes, that you're right. That was the order of 4th of May.
My lord.
Then there is a subsequent order of 18th of May, which says, as jointly suggested on behalf of the parties, let this matter be listed again on June 12 under the heading hearing amongst the first 5 items. Please look at the order.
No, I'm sorry. Then,
So
then,
it will be
then
listed.
I'm sorry.
Yes.
Hearing. Obliged.
ঠিক আছে, করে দিও.
This case, my lord, I am for the appellant petition in this case. There is some urgency in the matter, my lord. The order under challenge. Order under challenge is, my lord, dated, my lord, 4th of May 2023. The issue is, my lord, regarding the hydrant or the stand post, which is, my lord, the on roadside, you have seen. The stand post is, my lord, installed, my lord, for, my lord, supply of water on the roadside, my lord. It is, my lord, in front of my entrance of the premises. And, my lord, there are photographs to show that, my lord, it is causing a permanent nuisance to my ingress and egress to the particular premise for the 87B, my lord, turf road. But there was an order when the initially writ petition was moved by the before this bench, before this court, my lord. The court directed to take steps on whether it could be shifted from that place, my lord. Then a report was submitted by the Director General Water Supply. Then, my lord, he says, my lord, it can't be possible. That was the report, my lord. It has been annexed. Then finally, my lord, the court directed for filing evidence opposition and reply. That was done. Thereafter, the matter came up for final hearing before my lord Mr. Shaukat Bhattacharya. Then the court, my lord, again said that whether it can be looked into whether the shifting from that particular position, because it is causing my lord, on looking at the, my lord, the photographs, that it is causing my lord nuisance, then it could be shifted or not in a particular place. But my lord, that was not possible, my lord, because that there is in the midst of a particular pathway, and that cannot be possible. Therefore, my lord, the authority, my lord, again, my lord, submitted a report before this court. Then the matter came up for consideration. We raised our certain legal points before the court. That section 236 and 237 my lord, specifically provides on what basis and how it could be done. Apart from that, the legal, my lord, the formalities have not been done. It has been while it is installed. And moreover, my lord, even if it is, my lord, permissible, it is done, my lord, in accordance with law, then we have to, my lord, question about that, my lord, the correctness, if it is, my lord, taken, my lord, following the provisions of law. Moreover, my lord, the way, my lord, it has been installed, if your lordship can see some of the pictures, my lord, I have annexed at pages. Before that, your lordship, my lord, used to, my lord, look into the order itself. Your lordship, see the order. Then I
Let us
put the
go through
pictures
the order. Let us go
at
through the
page, my
order.
lord, the 33,
Let us go through the order.
at page 33.
Memo of appeal কেউ আছে?
এর মধ্যে দিয়েছি। প্রথম দিকে ওই একই ছবি আছে নাকি? কালার থেকে দেওয়া দিচ্ছে। বুঝতে সময় তো অসুবিধা। এগুলো দিকে বোঝা যায়। এরেস্ট করে দিয়েছি। তাতেও রাখুন।
Yes.
So my case was with reference to section, mainly with reference to section 237. The conditions, my lord, which are not, my lord, fulfilled here. I had a specific point, whether, my lord, there was an approval, whether the regulations have been framed or not, that was not answered. Then, my lord, my point is that the legal questions for the removal, because it is just, my lord, for entry of my premises, my lord, it has been installed. That the complete, my lord, the cleaning, bathing, and everything is going on. I have given the photographs, my lord. That photograph shows, my lord, you can see the photograph, that page, my lord. It's not, my lord, Xerox, my lord, that maybe, my lord, at page, my lord, 77. You can see 77 onwards.
So the learned judge has directed the respondent number 7 to take a decision.
Today, the date is
Well,
fixed.
therefore, my grievance is
Today, the
that,
date is-
just I have therefore, my lord, come because the respondent number 7, Director General Water Supply, he himself submitted before this court, my lord, 2 reports. The on-site basis, the court, my lord, finally decided, and then court again, my lord, directed him to.
We
Well,
change the officer.
Well, I am submitting, my lord, because also I want, my lord, that the so far as the legal points with reference to the facts be decided by your lordship, my lord. Whether, my lord, it should, my lord, remain there or not. Because, my lord, it is just, my lord, in front of my premises. Whether, my lord, the section 237 has been complied with or not. If it is not complied with,
Produce your records or file a report.
My lord, today is the date fixed.
so that, my lord, I do not believe in that person's word at all.
Not,
Therefore,
my lord, I
decided.
did not interrupt my learned.
No,
friend.
let me, my lord, finish my point, my lord, let my report.
When I start.
My lord, he has, my lord, these gentlemen, my lord, 2 reports, you can see, my lord. First of all, you can see 115. The first report.
Mr. Ghosh, we have understood.
Your lordship is
The learned-
the matter, let my learned friend file a paper book. Because my photographs along with the report has not been annexed.
I may, my lord,
Six weeks.
or my lord, leadership, my lord, here, maybe please.
So file a paper because that makes. File it
I will
within-
show, my lord, the entire argument is contrary to the record. My lord, the very finer point will come for decision. If a public right, if a private right is opposed to a public right.
We'll hear you, Mr.
Yes.
Mukherjee.
Yes.
Now, at the moment, what amuses me is that you and Mr. Ghosh are fighting.
At times we do.
দেখো এই জাজমেন্ট এন্ড অর্ডার ডেটেড ঠিক আছে রাই ওপরে অ্যাপিলটা শুনে নেবো dated May 4, 2023, whereby the writ petition of the appellants being WPA 24131 of 2013 was disposed of by a learned single judge, is under challenge in this appeal. Paragraph. The dispute pertains to the installation of, what is it called?
It's called, my lord, hydrant or stand post.
A hydrant oblique stand post by KMC in front of the residential building of the appellants. Stop. The appellants seek shifting of such hydrant. Stop. The learned judge, in effect, has directed the respondent number 7 in the writ petition being the Director General, Water Supply Department, Kolkata Municipal Corporation, to take a decision in the matter. Stop. Being aggrieved, the writ petitioners have come up by way of this appeal. Paragraph. Mr. Ghosh, learned senior counsel appearing for the appellants, says that the respondent number 7 filed 2 reports before the learned single judge, which are adverse to the interest of the appellants. Stop. The appellants cannot expect a fair order from the respondent number 7. Stop. Paragraph. Mr. Mukherjee, learned advocate representing Kolkata Municipal Corporation, says that the appellants have no reason to apprehend that they will not get a fair treatment from the respondent number 7. We anticipate the argument.
But actual submission is also disputed.
Stop. Mr. Mukherjee also disputes the allegation that the present position of the hydrant in question,
Stand post.
hydrant oblique stand post in question, is causing any inconvenience to the appellants. Stop. Paragraph. Mr. Ghosh has also raised a question of law, i.e., section 237,
36 and 237.
sections 236 and 237 of the KMC Act, 1980, have not been complied with in connection with installation of the hydrant in question or the subsequent shifting thereof. Stop. Paragraph. We see that certain legal and factual disputes are involved. Stop. We propose to hear out the appeal. Stop. Let requisite number of informal paper books incorporating all papers that were available before the learned single judge, as also the pleadings filed before this court, be filed within 4 weeks from date. Stop. All formalities are dispensed with. Stop. Since KMC is represented, notice of appeal is deemed to have been waived. Paragraph. List the appeal under the heading hearing amongst the first 5 items on 4 weeks. Aajke koto tarikh?
15th.
Today is
July, second week of, it will come after second week of July, third
Yes,
week
yes.
of July.
yes, on July 24.
Grateful one.
24. Stop. Since we propose to hear out the appeal at an early date, let the order under appeal remain stayed till the disposal of the appeal. This application being Can 1 of 2023 stands disposed of.
But the consequential notice we also the state, because the consequential notice in terms of that order has been issued at page P13, 9 June
The
2023.
order, impugn order, কি বললাম? As also, letter order under appeal, as also,
The notice dated
the
9
notice dated
9 June 2023.
June 9, 2023, issued by
The Director General Water Supply.
the Director General, Water Supply Department, remains stayed till the disposal of the appeal. Application to disposed of.
Immediate service be formally be kept with the record.
Four, you are for
Respondent number 9, municipality.
appellant,
I appeal on behalf of respondent number 10.
appellant, you are the appellant. All respondents are here.
Yes.
10 is who? Respondent number 10
Added
is
party,
who?
added party.
Added to the respondent number 10.
You are
Municipality.
state,
State is not, my lord, turning up. And this is our, my lord, affidavit in opposition to the application, my lord. Status. My lord, status.
you have been served.
Yes, my lord, the copy of the opposition has been.
Who is for the appellant?
No, my lord.
Yes, have you been served with a copy of the affidavit in opposition?
And I have also given them reply.
Opposition of?
The
Can
stay
appli-
petition, can
stay
application,
Can one.
can one.
Respondent number 9.
9 is the municipality. I am from municipality.
Who are you?
My lord, I am for the state respondents.
This is my affidavit. That is opposition of.
देखो affidavit in opposition filed on behalf of the देखो affidavit in opposition filed on behalf of the respondent number 9 and affidavit in reply thereto filed by the appellants be kept with the records. এটা রেখো তারপরে শুনি ম্যাটারটা।
10. 9 and 10 both have filed the opposition.
10 already filed. Earlier we have recorded.
Reply, madam, today I am.
Today, stop. Affidavit in reply of the appellants to the opposition of the respondent number 10 also be kept with the records. Yes, let us see the impugned order. Your writ petition has been dismissed. Disposed of.
Assuming that is a private dispute.
Let us see.
Chairperson of the Padram municipality is personally present.
Mr. Mathur, we'll read it. We'll read it. Yes, Mr. Mahato, what's wrong? What is your allegation? Your land has been encroached upon. What is your allegation?
My allegation is, my lord,
Take the microphone, please.
my lord, my allegation is, my lord, municipality has made a boundary. It is a fencing. My lord, although this land is my land, the club are in, according to record of rights, club are in permissive possession. But it is admitted position, they are in permissive possession. But
Permission,
from the record, it appears that they are in permissive possession.
permission granted by whom?
They have not disclosed it, but it seems, but from the record of rights, it seems that the trustees are there. My lord, kindly come to the records.
No, so ultimately, Mr. Mahato, it is your grievance that the club has been assisted or the club is in possession of your land.
My lord.
Writ court, how?
My lord, my allegation is not against the club's possession. I am not that they are encroaching. I have not to say that. My lord, my claim is, my lord, the fencing should not be made by the municipality at the dictation of the club.
First thing you will have a locus standi to make such a grievance if the fencing has been made on your land.
Yes.
Who will decide that? The writ court.
It admitted position.
Nothing is admitted.
But it is according to them, it is admitted position. My lord, a tenant.
Who is for the
Person.
municipality?
My lord,
Yes.
may I?
You admit that the land on which you made the fencing is his land.
No, my lord. What happened, my lord? Kindly sees their representation. Out of 1.6 and odd, my lord, decimals of land, my lord, acres of land, my lord, they are involved in this plot, my lord. He is claiming only 2.46 decimals, my lord. That is his land. It is his claim, my lord. So, my lord, large chunk of land does not belong to him, my lord. That is his admitted position. That apart, my lord, what happened? Initial trustees are not present, my lord. They are claiming that they are the heirs and successor of the original trustees. My lord, there is a provision in the trust deed that there should be a bylaw of the trust. They could not, my lord, produce any trust bylaw whereby they have been, my lord, inducted as new trustees, my lord. Kindly seize the trust deed, my lord. There is a provision in the trust deed that they will, my lord, frame a bylaw, and following that bylaw, trustees will be, my lord, appointed. They have not produced any, and how they have become, my lord, trustees, they have not disclosed it in the petition, my lord. So they are not at all, my lord, the owner of this land. If the trust deed is, my lord, believed.
Make your submission.
My lord,
Don't
these
take
are,
too much time.
what my Mr. Bhakat is saying, my lord, those are the scope of a suit. Those are not a scope of a writ petition. My lord, the scope of writ petition is very limited and very short. The activities of the municipality at the dictation of the club, whether that can be permitted.
So it is a PIL, my lord.
Dictation of the club is again a factual issue.
My lord, kindly come to page 20 of the application. This is the, my lord, record of rights.
Yes.
Page 20, my lord, the first plot number is 227. Nature, Khelar Mart. Remarks, Onumoti. My the right hand side, trustees Bibaran. My lord, got it. There are several plot numbers. The first one is 227.
227.
Yes, Kalarmat, that is the first plot.
Left-hand side, plot number column
227, yes.
2 to 7. That the nature is Khalarmat, remarks after 2 column, remarks Onumoti. And my lord, right-hand column, the trustees Vivaran, trustees Vivaran. My lord, here, my lord, from the bottom, 4th and 5th, Rahul Mahato and Dukhu Mahato are the petitioners before your lordships. Therefore, from the records, my lord, it appears in respect of all the lands, all the plots of land, we are the trustee. Maybe all the trustees have not joined, but 2 of them have joined. Now, my lord, kindly come
That
to
is another defect. 2 of them cannot maintain an action in law. The trustees must act jointly, all of them. So on that ground itself, your writ petition must go. Look up the Trust Act, very simple. Cannot.
my lord, when the activities of the municipality,
It's the law, Mr. Mahato.
that's my right,
Trustees have to act jointly.
I admit that. But sometimes, my lord, it is, my lord,
Sometimes there are disputes
so
between
far the
trustees.
petition is concerned, my lord, it has not been properly drafted in this way, but if it is, my lord, written as the petitioner is the trustee represented by 2 of them, in that event, my lord, this question would not arise. But here, my lord, 2 of them has made them petitioners. We, in this description.
How do we know that you don't have a dispute with other trustees? You have other motives for filing this writ application. Unless all trustees approach the court will not entertain, Mr. Mahato.
Well, in that event, we make an application for addition. Kindly adjourn, my lord, I shall make the application. If,
We'll
but it is
dismiss.
admitted position, the land is the trustee's land. It is admitted position, my lord, if your lordships kindly come to the report of the block land enforcement officer. It is at page 43.
Show us the admission that they have wrongfully, the municipality has put up a boundary wall at the behest of the club.
My lord, kindly come to page 43.
Yes.
Page 43, my lord, this report was submitted by the block land and enforcement officer pursuant to the order passed by this honorable court in the instant writ petition.
Very well. Use this as a piece of evidence in the suit that you will file. Use this. The BLLRO is hardly an authority to decide that A has encroached upon B's land.
Yes, yes. Now, my lord, kindly come to page 45. Well, kindly come to page 45.
Page
45. 45. This is the order, my lord, where the municipal authority was directed to remove the fencing in the instant writ petition.
Order was passed when the added party was not present in the list, my lord. This is before the added party was.
this order.
But municipality was there.
Yes,
And
Mr.
what
Mahato.
step municipality was taken?
Mr. Mahato, this order after the final order, what remains of this order?
No, my lord, I am not saying that. I am not. I am saying that I am trying to show that on the basis of this order, what step municipality took. My lord, kindly come to their report, the municipality's report. It is, my lord, at page 56.
Yes.
In compliance of the solemn order of the honorable court and in consequence thereof being directed by the chairperson Jharkhand municipality by such and such. We, the undersigned officials, were present beside the fencing of the ground near youth club today on such and such for removal of the fencing. Therefore, my lord, the municipality went to the spot to remove the fencing. But now today they are taking a different stand.
No, my lord. All along our stand was that they are not the sole trustees. And they are not the owner of this land, my lord. I have agitated this point before the landed single judge, my lord. But we could not, my lord, use affidavit, my lord, as there was no occasion to use the affidavit, my lord. There was no direction for that. So we could not present our case entirely.
Now we have filed an affidavit here.
Yes, we have filed, my lord.
You have said that they are not,
Yes, we have stated that bylaws are not there. They are not inducted.
what is not there?
Bylaws
Bylaws.
as proposed in the deed, my lord. That is not produced by them, my lord. How they have been inducted as trustees.
The another document I shall show to your lordships, the letter written by the club to the municipality. It is with their opposition, page 36.
Club is number 9,
My lord, I am number
10.
10.
Yes.
Yes. Page,
Page, my lord, 36, page 36 or 19, দুরকম number কেন? 36, it should be 30. Annexure F,
yes.
letter head as the Raghunathpur Youth Club, the respondent number 10. I, Sri such and such, being one of the core committee member of the youth club, on behalf of this club, have the honor to inform you that Raghunathpur Youth Club is the registered club. The registration number such and such. The registered office of Jhargram Youth Club is situated at District Jhargram, Post Office Police Station Jhargram, Mauja such and such. The land description is the disputed land. The block land ransom officer Jhargram recorded this youth club and its playground in LR record of right as permissive possessor. The holding number such and such youth club and its playground is the building of Jhargram Youth Club was built up in the year 1973. The gymnasium of Jhargram Youth Club was inaugurated in presence of the respectable persons of the locality in 98. The playground of the youth club was covered by the bushes all around at that time. Later, the members of the Jhargram Youth Club decided to uproot the bushes for the plantation of all around the playground. The plantation started during rainy season of every year all around the playground. Since then, now the playground is covered by different green trees all around. The playground is present such as roughly such and such.
Mr. Bhatt, don't read the whole letter.
No,
Read
my
the
lord,
whole letter. Come
Next
to
one.
page 38, the last paragraph.
No, my lord, kindly next paragraph. There are more than 1,000 families of ward number 15 and also the adjoining wards of the youth club ground. They have only open space to take free air from the youth club ground. My lord, kindly consider everyone has made their construction over their land and now they are, my lord, looking at the land of the petitioners. Therefore, they will use according to their will. This youth club ground is, kindly consider, this youth club ground, it is not their ground. They are in permissive possession, but they are claiming it is youth club's ground. They are claiming that their title is looking a green zone surrounding the area, such and such, such and such. Now, kindly come to next page, page 3. This youth club and its green ground. Again, my lord, they are placing that it is our ground.
In the affidavit, we have said that we have permissive possession. We have never claimed the title.
Therefore, if it is permissive possession, it cannot be their ground. Now, my lord, last paragraph. At last, this youth club called a general meeting in the club ground to save green grasses of the playground and its surroundings. And these youth club members decided to request the chairman of Jhargram municipality to make a peripheral fencing besides. Therefore, my lord, asking that whether the municipality has acted at the dictation or request of the club, this is their admission. My lord, at the request of the club, the municipality has, my lord, made the fencing. My lord, can it be done when the owner is the different persons? On the basis of the permissive possession, who is in permissive possession, can the municipality make the fencing? This is the scope of this writ petition. They are not the owners. Without consulting the owners, can the municipality make the fencing? This is my only question.
Very well. Issued. We'll put it here. A judgment and order dated November 17, 2022, whereby the writ petition of the appellants being WPA 7848 of 2020 was disposed of, is under challenge in this appeal. Paragraph. The crux of the grievance of the writ petitioners oblique appellants, as would appear from the papers on record, is that a youth club has encroached upon the land of the appellants. Not only that, the concerned municipality, at the behest of the club, has put up a boundary wall, oblique fencing, on land belonging to the concerned trust, of which the appellants oblique writ petitioners are trustees. Paragraph. The learned judge had initially passed an order. Where is that? The first order that was passed?
Different occasion, the order was passed, page 45.
45. Initially passed an order, interim order dated August 30, 2022, interim in nature, with the following observations. Page 46, 47. Paragraph. That order was passed in the presence of the municipality, but the added respondent, being the club in question, was not before the court. Paragraph. Subsequently, the club applied for being pleaded as a party respondent. You were added. Such application was allowed. After hearing all concerned parties, paragraph. After hearing all concerned parties, the learned judge passed the order under appeal. The learned judge disposed of the writ petition with the following observations. Internal page 3 of the impugned order. Paragraph. Being aggrieved, the writ petitioners are before us by way of this appeal. Paragraph. Firstly, Mr. Mahato, learned advocate representing the appellants oblique writ petitioners, has candidly submitted that the writ petitioners are two of several trustees. All the trustees have not joined to file the writ petition. On that ground alone, in our view, comma, the writ petition is not maintainable. Stop. Although this point was not urged by any of the respondents before the learned single judge, nor the learned single judge considered this point otherwise, comma, since it is a pure point of law, comma, we can't overlook the same. Stop. It is established law, and the provisions of the Trust Act make it clear that all the trustees of a trust must act jointly. Stop. That is not the case here. Stop. In our view, comma, the writ petition is incurably infirm and not maintainable. Paragraph. Even on merits, comma, what appears from the submission made on behalf of the parties and the papers on record, comma, the dispute between the parties and the grievance of the appellants oblique writ petitioners pertain to encroachment on the land of which the writ petitioners claim to be owners as trustees. Stop. The learned judge has rightly come to the conclusion that such a question cannot be decided by the writ court. Stop. The learned judge has left it, has reserved liberty to the writ petitioners to approach the appropriate forum with their grievance. Stop. Paragraph. Learned advocate for the appellants drew our attention to a letter written by the club in question to the chairperson of the Jhargram municipality, letter dated November 10, 2022. Written by the club in question to the chairperson of the Jhargram municipality, bracketed out annexure F to the affidavit in opposition of the respondent number 10. Take a bracket closed. Stop. With reference to the said letter, comma, learned advocate submitted that the municipality is acting at the dictates of the club. Stop. The boundary wall oblique fencing that the municipality has put up is as per the request of the club. Stop. This cannot be done. Stop. Paragraph. It is true that the municipality has a duty to act in accordance with the relevant statute. Stop. However, comma, still the question of encroachment remains. Stop. In our considered view, the appellants have been rightly relegated to the civil forum by the learned single judge for the purpose of ventilation and redressal of their alleged grievance. Paragraph. We do not find any reason to interfere with the judgment and order Under appeal, stop. The appeal and the connected application are accordingly dismissed. Stop. There will be no order as to costs.
Only there is dispute of fact that we have urged the point of locus standi,
You have
agitated this point before the learned single judge.
locus standi.
Yes, at page 49, before the learned single judge.
Very well. I শোনো একদম গোড়ায় একটা এইটুকু দিয়েছিলাম অপূর্বকে, সেটা নিয়ে নি
My lord, item number 5 to 22 are identical matter, my lord. In this matter, my lord, yesterday, Mr. Shankar Biswas argued before your lordship, my lord. This matter, my lord, I am praying for day after Monday, my lord. As because my lord's verdict, we have to look into thereafter, we
What will you look into? Supreme Court has held.
yes, my lord.
And we just recorded that Supreme Court has held no compassionate appointment can be given if there is no scheme. That is all.
Yes, my lord.
Why do you want to keep it pending, sir?
And he has not come today, my lord, so I am praying for my lord has also some verdict, my lord, and I have.
What verdict?
Will pronounce, my lord. I have not got till date after.
আমাদের সার্ভার হয়নি কালকের অর্ডার, দেখো তো একবার। Come back tomorrow. Come back tomorrow. Let us dispose it of, sir. Why keep?
My lord, Monday, my lord, praying for only Monday.
কি অর্ডারের কপি দিয়ে দাও একটা। Sir, but why are you saying, what purpose will it serve? Tell us. What purpose will be served?
My lord, in this matter, my lord, Biswas is my senior, my lord, he has not come today, my lord. And I have also not briefed with me as because there are so many 5 to 22, I have not.
Identical.
Yes, my lord.
Same order will be passed in all the matters.
Yes, my lord, only, then not today, my lord, only then.
Not today. Come back tomorrow.
My lord, my lord.
Come back tomorrow. অর্ডার পাস করছি না কিছু, কালকে থাকবে 5 থেকে 22, নট টুডে করে রেখে দাও।
My lord, I am appealing for the appellant, my lord. My lord, in January 2021, I filed this appeal, my lord.
Yes.
This first time this appeal is coming up. In the
Yes, because you were not interested
No, my
in
lord,
listing this appeal.
my lord, lordship, I beg for 2 weeks' time to get updated instruction from my client. My lord, lordship, kindly grant me for.
Is this fair? You are all advocates of this court. You will just file an appeal, keep the records of the court burdened, and take no steps. This is appealing at our instance.
Lordship, kindly. 2
Not
weeks'
right.
time.
No, not 2 weeks, 1 week. A sufficient time to take instruction.
Since the Eid festival is there ahead, my lord.
What is there?
Eid festival is there, my lord, a personal ground, my lord. I beg for 2 weeks' time only, 2 weeks' time.
Anyway, 2 weeks.
It kindly be after
After
3rd of July, my lord. I will be
the
coming back with the entire instruction and
learned advocate for the appellant says that this appeal was filed in 2021.
I have already served the notice upon all the respondents.
We are surprised that no step was taken by the appellant for enlisting this matter since then. Stop. This matter has been listed at our instance. Stop. We deprecate the practice of litigants filing appeals and not taking any steps for proceeding with the same. Stop. Paragraph. As requested by learned advocate for the appellant, let this matter stand adjourned till
After 3rd of July, my lord.
July 3, 2023 to enable him to obtain instructions in the matter.
Grateful.
Okay, and where is the, have you filed any application?
My lord, I have filed an application for stay, my lord, it is there. also.
It says no can in the list.
No,
find
I-
out.
I have filed. I have filed it. So for my
Who-
office,
Where did you file, in the court or in department?
it is filed in the department, my lord, in the filing section, I think that's been filed.
Look into it.
My lord. I will take steps.
There is an endorsement in the cause list that the can filed in this matter, the application for stay filed in this matter is not available in the records. Stop. Learned advocate for the appellant shall look into the matter. Stop. If the application filed in the department cannot be traced, comma, learned advocate shall file two authenticated copies of the application in court on the adjourned date.
I shall.
24. I'm for the Howrah Municipal Corporation. led by Mr.
24. দেখো 18, 16 এইসব বছরে 14, 11 আছে তারপরে second call. এই বলে দাও ইউজুয়াল তো আমাদের দিকে তাকিয়েও না ফর্মুলা
Howrah Municipal Corporation.
বলেছিল বসুটা এটা দেখো এগারো সালের মামলা কিছু বাকি আছে এটা আমার খুব সন্দেহ 37th your application dismissed. ওইগুলো তো রেকর্ড হয়ে যাবে automatically.
Item number 15, Mr. Supreme Court,
He's appearing for the appellants.
Yes, ma'am.
Very well. Pass it over. If in the second call he is not there,
Not to the matter.
very well, not today.
Good for me.
I am for the appellant.
Respondent,
Appellant.
appellant. Other side, We'll take up in the second call, no problem. In the second call, if your other side is not there,
No, DC, the matter before Lordship, the municipality matter, the dying Hanish case.
yes.
Single bench erected,
Oh,
that matter, His Lordship several times appeared before His Lordship this matter. The
now the,
state government went to the Supreme Court,
that is in that Devabruta Tiwari.
Lordship,
Now Supreme Court has decided that.
decided that and
So we can't grant you any relief. What can
Lordship.
we do?
Lordship,
Let us dispose it of them.
can you, Lordship?
এই কালকের অর্ডারের কপি বার করো একটা। Yesterday we disposed of 6 appeals.
কত আপনি এটা হয়ে যাক
আর এই ফাইলটাও দাও। ফাইলটাও দাও।
SLP was admitted and set aside the order of the on judicial bench.
In this case, in your case, the learned single judge dismissed your application.
Lordship.
Mr. Salahuddin, your appeal is against an order passed in contempt jurisdiction. Look at your memorandum of appeal. The impugned order is dated 22nd November 2019, passed by learned single judge in CPAN 520.
No, Lordship, DC. Order dated 22nd 11/29, passed by the Emergency Court, WCRC 1999, CPN. Yes,
In contempt.
Lordship.
This appeal doesn't lie at all. This is not your order against the, this is not your appeal against the order dismissing your writ petition.
Lordship.
The learned judge dismissed your contempt application. Rule was discharged.
That is, my lord, fact. That is the fact.
Yeah, so therefore. appeal takes like one. File করেছিল কিসের কন্টেন্ট কিছুই বুঝতে পারছি না কিছু। এই যে WPCRC মানে রুল ইস্যু করেছে। রুল ডিসচার্জ হয়ে গেছে তার এগেইনস্ট এসো এসো এসো। This appeal is directed against an order dated November 22, 2019, passed in contempt jurisdiction by a learned single judge. Stop. The order was passed in CPAN number 520 of 2019, which, after issuance of rule, was renumbered as WPCRC number 99, bracketed W of 2019. Stop. The paragraph, by the order impugned, comma, the learned judge discharged the rule and closed the contempt proceedings. Stop. Such an order is not appealable under section 19 of the Contempt of Courts Act. Stop. Nor is the order impugned a judgment within the meaning of clause 15 of the latest patent. Paragraph. Hence, this appeal is not maintainable. Stop. The appeal is accordingly dismissed.
Number 31.
Loss, better loss.
30, 31, you lot.
Which one?
31, my lord.
Unta ki bolche?
For default,
Unta.
31, my lord.
Corona.
And kindly not to.
Find out. It says cannot here. Find out. Find out. Not this week.
Item number 36, you lot is dismissed for default.
Take the microphone.
Oh, yes, man. 36 already was the matter has been settled, my lord. So I am not further proceed the matter, my lord. 36.
So let it stand dismissed for default. No. Acha, 36 ta order karo. You are for the appellant.
Appellant. Well, instructed by the appellant, my lord.
Learned advocate for the appellant says that this matter
Already
has been amicably settled between the parties out of court. Stop. He has instructions not to proceed with this appeal. Paragraph. The appeal and the connected application being such and such are accordingly dismissed for non-prosecution.
Lordship,
Get
31 ta ye corona, 31 ta order corona.
Lordship,
31, find out where is your can. Can is not in the department. It will be listed again on Monday.
My lord, item number 37.
Yes,
I'm for the petitioner, my lord. This was for restoration.
yes.
I was on the leg running from that building, my lord. Kindly restore this matter on our.
Very well. Move it, move it. Where is your brief?
My lord, my senior is on the way.
Restoration, we will not allow your senior to argue. You will argue.
Give me then 1 day time, my lord. I will do it.
Not today. Restoration, sir, not today.
Grateful, my lord.
Lordship, item number 28.
Yes.
I think it has been dismissed for default. I was in court number 32. Kindly, if,
Corona 32.
and Lordship,
28.
I don't have necessary instructions from my client. Kindly 1 week time maybe.
28 adjourned for a week. Kore rekhe dao.
Grateful, Lordship.
Six. 47, 48, 49. There was a similar type of appeal matter. Another matter is not appearing all together. I can give that number and one thing matter instructions that I've yet to receive the formal instruction, but I've heard that matter has been sent out of court.
Settled out of court. So what should we do?
I think let that fourth matter appear
Monday.
and give 2 weeks time matter.
Why? Settled out of court, just make a phone call, ask.
I'll bring that up.
1 week, 1 week. এটা দিয়ে দাও, নাম্বারটা দিয়ে দাও। কিছু অর্ডার করতে হবে না। নেক্সট থার্সডে এইটা, এই শোনো, এটার পরে দুটো অর্ডার করতে হবে না তো? দিয়ে দাও নেক্সট থার্সডে।
My lord, I have the apple.
54.
Lordship, I am on behalf of the appellant, Lordship. Lordship, I am appearing virtually. Due to unavoidable circumstances, I am appearing virtually, Lordship. And I am on behalf of appellant.
What is the unavoidable circumstance?
Actually, Lordship, from yesterday night, I am suffering from a lower abdomen pain. And due to that reason, I am appearing virtually. But presently, today, I am okay, Lordship.
You want an adjournment or you want to do the matter? What do you want?
Lordship, I want to do the matter, Lordship.
Well, in the second call, let us see.
Lordship.
Second call. ছিল না, সব থাকবে না তো, 16 সালের অ্যাপিল। Usual.
Can I show now? CRR 185 of 2023. Sir, on 17th of May. 45. 46.
ছেড়ে দাও, pass over.
My lord, this is that
Shikar.
I'll tell you, Lordship,
Not this bench,
not
Mr.
this bench. Well, I'll tell you, Lordship, one thing that has happened. Your Lordship stayed the counterblast, the FIR on the Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. I advised my client they should file a regular 482.
Yes.
They filed it, but that has not been assigned to this one because the judge who was taking up the determination thought that your Lordship should hear it because your Lordship has already taken a prima facie view and state coercive action. It was sent to the Chief Justice. Chief Justice, after going through the paper, they said, no, it should, the same one should be with it. So it has been assigned, we will let it appear together before the your Lordship.
বুঝতে পেরেছো? দেখে নাও।
My advocated record is here, my lord. He will give the CRR number and the cost title. Let it be tagged on with this matter.
Let these matters be listed, not on Monday, Wednesday.
Before the
Regular bench.
regular bench.
Hopefully the regular bench will assemble on and from Monday.
That is, my lord, that way, that depends.
Health issues.
So what happened?
Yes.
Only the CRR should be tagged because it's been assigned. We moved it. Your Lordship, I advise them they should go to the regular criminal bench. That criminal bench, we have to annex some of the orders passed by your Lordship to give the background. After having gone through the orders, the Lordship was taking up the jurisdiction, felt that your Lordship should take it up because your Lordship had more in-depth knowledge of the issue. And my lord, one thing, they have filed the Superintendent of Police, your Lordship, they have filed a report. Action taken report, we want to give a rejoinder to that, let it leave be given because there are a lot of things in that who people who on the ground say, my lord, do not reflect what actually took place. I'm sorry to say that. So they want to file it is up to your Lordship, they are senior officials, they filed a report. We want to comment on that report, which we are entitled as members of the civil society.
Let us cross that direction, we can, because this bench is taking up the determination of that regular bench.
Yeah, so just the direction, that's the direction.
When was this report? What report is this? We don't know. report dated,
This time
report dated,
Report dated কি? Report টা কি আছে? He does not know, my lord. I will give the date. I just come running because I thought the matter I didn't get the brief. My man is still here.
why don't you do this? Why don't you keep your reply ready?
Yes,
We'll allow you to file, we'll grant you leave on the next date.
yes. On the next day, and
Keep it ready, keep it ready. We'll grant you leave to
Yes,
file, yes. So Wednesday it will appear.
so then kindly adjourn it for a fortnight, my lord, in case they take more time.
Very
So
well. Lekho,
Today is the 16th, 15th. 15th of June. Kindly keep it on the 30th of June, then
29th.
29th.
এটা কত নম্বর?
52.
52. হ্যাঁ। Mr. Siddhartha Mitra, learned senior advocate representing the petitioners, says that his clients would like to file a response to the report filed by the superintendent of police.
Police Jhargram and West Mendipur.
Superintendents of police, Jhargram and West Midnapur, Paschim Mendipur. What official name here? Paschim Mendipur.
Paschim Mendipur.
Stop. Let such report, let such response be filed before the next date with advance copy to learned advocates for the state and railways. Paragraph lists the matter once again on June 29, 2023 as the number 1 item under the heading contempt application. Stop. Let এই দিয়েছেন ওইটা কি এটা অ্যাসাইন্ড হয়েছে নম্বর দিয়েছেন
He will write it down and give it to you.
একটা নম্বর দেবে হ্যাঁ also be listed along with this matter on the adjourned date. Records নিয়ে নিও.
record is in the.
I'm told the records have come, the criminal division records have come to this court.
I'm in 16 of a report, my lord, Superintendent of Police Jhargram, my lord. There, my lord, there were 2 incidents which was reported to us. One was for the 15th of May, another thereafter was on the 16th of May, my lord. We have taken necessary steps and there are compliances so that there is no untoward incidents, my lord. The informations received officially on the.
If you wish to file a report, Mr. Nag, you are at liberty. Paragraph, Mr. Nag, learned advocate for the state, not state, you're for the alleged contempt laws.
Contempt.
For the alleged contempt laws.
The difficulty is alleged contemners is not the Jhargram superintendent. The alleged contemners are the forest department officials, my lord. However, my lord, as generally I represent the state, my lord, I am. This will be a bit complicated.
It's a technical thing, doesn't matter. Mr. Nag, learned advocate appearing for the respondents, says that the concerned authorities have taken some certain steps pursuant to the report of the
informations, my lord. We have
information received from
my lord, one information on the for 15th, my lord.
No, received from whom?
My lord, one Orko Sarkar, president of Hill.
Information received from bolte হবে না pertaining to untoward incidents. Stop. The respondents will be at liberty to file a report to bring on record the steps they have taken in that regard, before the next date, with copies to learned advocates for the petitioners and the railways. 29 বলাই হয়েছে তো আগে.
This is a second report because they already given non-report.
They are saying that they got some information about atrocities, so they have taken steps. They want to bring that on record. What steps they have taken that they have been good boys.
Now, when the shikar season is over,
The shikar season is over now. There is no hunting but now. Shikar is linked to certain planetary movements. Those planets have moved, so shikar has stopped. So now everyone is free to say he's a good boy.
In this heat, I can only think of shikara.
But you may be a shikar in a shikara.
And that among this discussion, I can vouch that I am a good boy.
You're a good boy. Very well, 29th.
Obliged, my lord.
Some training in Mussoorie IPS officers perhaps, but I'll tell you lots of one. Oh, this is beside the point. A friend of mine, his son, passed the prelims, mains, as well as the interview. He could do the IAS as well as IPS. He knows me from childhood days, school, Mayo and all that. So he asked me whether or not the person should join. He had a chance to go to the US for further studies. I said, my personal experience with the people in the service is such that you send your son to US, ask him to give up this service. One of the very few, after it's quite a difficult thing getting through the prelims and mains, and he gave it up and he went to the US. Yesterday he called me and said, I thank you for the advice. This is the best thing that could have happened. Because two of his other friends who are in the service now want to leave and go. Because they said, we wanted to serve the nation, ended up serving something else.
Very well.
So, my lord, this is a brain drain. Anyone good goes. And they said I was being very unpatriotic by telling them to go abroad. I said, look, my life is over. Why should I spoil another person's who's starting off his career? Ask him to join the IAS and then get instructions from people who are not even qualified to give instructions.
All right, Mr.
Yes.
Yes.
My lord, I am for the petitioner that matter
Yes.
has been heard by
Regular bench,
my lord. Monday.
Monday.
I am for the appellant.
But I propose response number 8. The
Lordship, heard this matter.
that housing cooperative society matter regarding conversion of the car parking space into a shop.
Oh,
That matter.
on Monday, Mr. Sharat. We heard it. That bench heard it, huh? Monday.
Everybody is present. Very short point is in for your lordship knows. On last occasion, your lordship directed my landlord
But
to
they
take
took time
instruction.
to come with better,
Not that
paper
what the-
qualities were not good, it's not legible, so my lord was supposed to give them time to come with better.
Take
particulars.
instruction.
Achha.
Your lordship knows, my lord, already your lordship passed an order holding that the order of the learned signature directing to raise fresh dispute is not required. Since already you have raised the dispute and he has admitted that claim that there is an unauthorized production, I shall.
What are you suggesting? We should take it up today.
Appellant. অন্য মাটা বলছো
54.
Yes.
in another matter.
Please, your lordship. Lordship, I am ready with this matter. If lordship convenient, then I am ready to start.
Everybody is ready. Graveyard.
Come back on Monday, Mr. Sharat.
Great.
Sombar, regular bench to topic. My lord, item number 55, my lord, I am appearing for the respond number 7 to 11. My lord, there was a direction of your lordship.
Item 54 will remain in its position.
54, হ্যাঁ, zero আছে, 1 নম্বর item.
My lord, item number 55, my lord, I am for the respond number 7 to 11, my lord. There was a direction of your lordships to the appellants to file an informal paper book, but they have, my lord, not yet served us. The order was of November 2022. And there was
2013 appeal.
And there was a direction on last occasion, my lord, the matter was restored. Your lordship was pleased to direct them to pay 1,000
Where
rupees.
is Mr. Mukherjee? Tomorrow? Not.
I am for the appellant.
So, short matter or long matter?
My lord, far as the lordship has to decide the issue. The selection from the basis of the marks obtained in the secondary examination, ASA. My lord, the
Appellant before lordships, my lord, appeared before the interview board. Interview board, my lord, selected her. She was engaged, and my lord, she was sent to trial. She worked.
This is
My lord, the respondent number 7, my lord, the writ petitioner moved the writ before the Honorable Court that I cleared the examination, though I got third division, on one chance, and my client, the appellant for lordships, she cleared the examination with compartmental. This issue was before the court. Then, my lord, this Honorable Court said no. The person, in examination, the appellant secured 453 marks with compartmental. She secured third division, secured 365 marks. Selection committee, my lord, selected her. Her means, my lord, the appellant first time. As the rule says that the marks, my lord, the selection should be made on the basis of the marks obtained, not the first chance, second chance, or third chance. That happened. This Honorable Court, my lord, in two terms, my lord, my lord, this Honorable Division Bench, my lord, stated that as the examination rules of secondary examinations 2001 says that regarding the compartmental, I have stated that though compartmental passed, but these divisions will remain. Compartmental, I got more than 400 marks, then in second division. Now when the appeal was preferred by this Honorable Court, this Honorable Court was pleased to pass an order, my lord, staying the selection second time made on behalf of the writ petitioner. Now this point will be decided by your lordships in this court. First, the appellant was selected. She worked against her selections. The writ petitioner moved this before this court.
Mr. Dash,
my lord.
Your junior has prepared this paper book.
My lord.
Have a look at this. Have a look at the index. Have a look at the index, Dauto. Have a look at the index. How are we supposed to find out the page number? Look at it.
I'm very sorry, my lord, I may be excused for that.
Kindly ask your junior to make the necessary
My lord, my lord.
correction, and please ask your junior to serve notice on the learned advocate for the other parties.
My lord.
This is a 2013 appeal.
Yes, my lord. As a result of what both are not working. My client who worked there, pursuant the courts, her appointment has been cancelled. Now she is pursuant to the order of this Honorable Court, my division bench, the second the writ petition is not to work.
There is some defect in the index of the paper book. Stop. Let such defect be rectified by learned advocate on record for the appellant. Paragraph. Since this is a fairly old appeal of 2013, let fresh notice be served on learned advocates for the other parties, intimating that this appeal will be listed again 1 week on next Thursday, the other.
My lord. I may be excused, my lord, that should not have been done. Yes, my lord. Paper book is given. Oh, sorry. I'm so sorry. এইখানে পেপার উৎসব
57, my lord. All humiliation and hesitation, my lord, I'm submitting, my lord. Paper book was direct.
No hesitation is showing on your face.
Hesitation and humiliation is there, my lord, because paper book direction was there, my lord.
You are the appellant.
Yes, my lord. Extension of time may kindly be given.
How long?
15 days, my lord, kindly be given, my lord.
When was the direction given? Last?
In the month of September 2022. And direction was, my lord, on matter to appear on 7th November 2022. As hearing.
Mr. Ghosh is not opposing your prayer.
Generally not, my lord.
Oh, it's our order only,
Not, sir.
14th September.
Not, sir.
Time for the appellants to file paper book. We file paper books in terms of our earlier order dated. In terms of the earlier order dated September 14, 2022, is extended till আজকে হচ্ছে কত তারিখ 15th June 30. Stop. Paragraph lists the matter.
1 week after, my lord. 1 week after that.
On July 17.
Deeply.
Then if you want some more time, we can grant you some more time because July 17th. So to be time to extend kore dao till July 10.
Deeply.
It is better this way so that you don't come back and ask for more time.
Extension dilo, he may come again.
Unauthorized construction, my lord.
It is the order of the tribunal.
Always we are trying to avoid the honorable court, my lord, because we know, my lord, the zero tolerance of the honorable court.
Absolutely.
The KMC, my lord, has made, my lord, 2015 that particular amendment, national disaster, loss of national property and all these things. Their subjective discretion will be applied. Some people will be in the blue light and some people will be thrown out. My lord. That being the situation. That being the situation.
They have to look into everything.
To pamper blue-eyed persons, my lord. Deeply.
Lordship, item number 58, I am on behalf of the appellant, Lordship.
My lord, I'm appearing for the municipality, my lord.
Well, I am appearing on behalf of the private respondent, my lord.
Very well. Is it a long matter?
No, my lord. It's a very
No,
short.
my lord.
This is not a long matter, Lordship.
My lord, very short matter, my lord. The order has been passed by the honorable single bench, my lord, and the municipality was directed to take a decision. Thereafter, my lord, the petitioner preferred this appeal, my lord. During the pendency of this appeal, my lord, the municipality has already passed an order, my lord, after taking inspection.
No, Lordship, the clear fact is quite different from this submission. Lordship, with your Lordship's permission, I am revealing the brief fact of this instant matter.
No. Permission not yet granted. We are going to go through the impugned order first.
Yes, my lord. Page 84, my lord.
Page number 80. I humbly draw your Lordship's kind attention on page number 84.
Yes, thank you. Let us read it.
Yes, my lord.
In 1 minute. My lord, in short, it is a feud between the two brothers regarding a shared household that was gifted by the mother.
We have seen that they want a separate septic tank.
Which is a shared, and they have agreed to that. If your lordship kindly comes to my lord, page number 40. It is a gift deed by which the appellant hearing, Mr. Arijit should have received. My lord, prior to page 40, if your lordship kindly comes to page 24, just to show that Mr. Arijit should is the appellant hearing who had received his property as a gift. I am also the brother. He is my younger brother, I am the elder brother. Page 24 depicts that it's a deed of gift. This is in continuance. If your lordship kindly comes to page 40, the schedule of the property, what he has received exclusively, and what parts he has received in a shared hold purpose. Schedule B, all the piece and parcel of one flat on the ground floor measuring about 460 square foot superbuilt area, be the same or little more or less, consisting bedrooms, one dining room, one kitchen, one latrine, and a mezzanine floor measuring 158 square foot, total floor area 618 square foot, all this he has received. Thereafter, from the last line, fourth line, which is clearly shown in the attached plan map in the red border lines along with the undivided proportionate share of common areas and facilities within the building, including all fittings and fixtures mentioned in Schedule C. The next is Schedule C, my lord. My lord, item 7. Item 7. This is what now he has agreed and he has received this. Now he wants a separate septic tank, which is not possible, my lord. It's a municipality.
My lord, I am appearing, my lord. My lord, your lordship, kindly see the, my lord, I am reading the relevant portion of the order, my lord. My lord, more importantly, the total area of the property is 2 kata and 7 chatak. In my opinion, it is not feasible to have 2 septic tanks there. Thereafter, my lord, the direction upon the municipality. However, I direct the South Dam municipality to make a suitable inquiry into the matter so that separate municipal drainage facilities are provided to 7A and 7B taken together and 7C taken as a separate unit within 6 months of the communication of this order. My lord, during the pendency of this appeal, my lord, the inspection was held by the municipal authorities, my lord, and my lord, hearing notice was given, and after giving opportunity of all the parties, the municipality has already passed an order, my lord. My lord, my junior is there, my lord. He is holding the copy of the order. Your lordship, kindly see, my lord, the orders. If he is aggrieved by that order, he may challenge.
1 second.
Yes, my lord. Yes.
Lord, can we have a copy of it? My lord, we want to file an exception to this UP document file here, my lord.
My lord, my humble submission before your lordships, my lord. My lord, the municipality has already passed an order in compliance with that order, my lord. If they are aggrieved by that order, they may challenge it, my lord.
Just we have received the report.
Lordship, kindly allow me to say something, Lordship.
Because my lord, here, if it is feasible, then do septic tank, it is not feasible. Once he has
Lordship, in that event, Lordship, I am on behalf of appellant. Lordship, kindly allow me to say something, Lordship. Lordship, am I audible, Lordship?
Yes, you are. Municipality,
Yes, my lord, I am appearing, my lord.
let us have a look at the.
Yes, my lord, your lordship, kindly see the order dated 28th July 2022.
You are Ranjit Shur, my lord. But it's a common area that you want to be divided, which is not possible, my lord.
Fasting lordship, before filing the writ petition lordship, we prepared one application under Right to Information Act, and under Right to Information Act, we wanted to know that one common septic tank may be allowed for the several owners. Answer is, lordship, I have attached this RTI answer with the writ petition. Lordship, kindly come to page number 75, lordship. Kindly come to page number 75. And lordship, vital thing in this instant matter is that the grievance of the petitioner is divided into two parts. One part is related to septic tank, and another part is related to the illegal construction. And now the $1 million question in this matter is that why the order which is impugned, is liable to be vitiated, because in the order, which order has been passed by honorable single judge, in this order regarding illegal
Mr. Mukherjee,
lordship,
are we visible? Can you see us?
lordship,
Can you see that we are trying to read something and you are just Chair?
lordship, in that even I am praying for apology, lordship.
Now, Mr. Mukherjee, this report has been filed by the municipality in terms of the order of the learned single judge. This report rightly or wrongly says your prayer cannot be, your request cannot be allowed. If you are agreed by this, you have to
Yes, my
challenge
lord.
the report before the appropriate forum.
Yes, ma'am.
Lordship, in that event, lordship, you are not visible, lordship.
কেন আমরা visible নেই বলছি?
Now, presently you are visible, but sometime you are not visible, lordship. Lordship, in that event, lordship, with your lordship's permission and subject to lordship's correction, I want to mention one thing, lordship. Only one thing, lordship. If I go over the grievance of the petitioner with fine tooth comb, then it is revealed before me that his grievance is divided into two parts. One part is related to the septic tank, and another part is related to the illegal construction. Now, lordship, I am asking myself why the order which is impugned in nature, in this order foxpass has been committed. Why I am saying it? Because, lordship, regarding illegal construction, the order of learned single judge did not say anything, lordship, regarding illegal construction. Already I have mentioned the detail of the illegal construction in my writ petition. Despite my pleading, any statement has not been mentioned in the order passed by honorable single judge regarding illegal construction.
You made any representation to the concerned municipality as regards alleged illegal construction? Have you made any representation?
Your lordship, kindly see the representation, my lord. My lord, the representation is annexed at page 80, my lord. Your lordship, kindly see the prayer of the representation. It starts from page 80, and my lord, the prayer portion, page 83. There is nothing regarding unauthorized construction.
There is no unauthorized construction, in fact. Even the
Your lordship, kindly see, my lord.
my lord. Yes, this is your representation, Mr. Mukherjee.
There is nothing about unauthorized construction, my lord.
Whisper about unauthorized construction.
Lordship, it is a fact, and this
What
fact
he is
cannot,
submitting, my lord, before your lordship.
this fact cannot be denied. This fact cannot be denied. But when a writ petition, this
And your
matter
lordship
has
kindly
been
see the
mentioned-
prayer of the writ petition, my lord.
Even there is no amendment also like that. In the
Your
prayer,
lordship kindly see the prayer of the writ petition. What he is submitting, my lord, that there is twofold prayers. Your lordship kindly see the prayer of the writ petition. Direction upon the respondent authorities to consider the representation. Kindly see, my lord, page
Yes,
18.
we have seen, madam, we have seen.
Yes, my lord.
Yes, Mr. Mukherjee.
Lordship, in paragraph number 8, that is the page number 14 of this paper book, the averment regarding the illegal construction has been taken in the writ petition.
Page 14.
Page number 14, internal page number 8, page number 14 of paper book.
Now, you please come to your prayers. Come to your prayers. And please read prayers A and B.
Lordship, I have read the prayer. Lordship, it is not mentioned in the prayer. But Lordship, being a law student, I am asking myself, Lordship, in the averment, it is mentioned. It is mentioned in the averment, and that's why the matter has been put in the notice of the Honorable Court.
Very well. If you have agreed,
And Lordship, subject to
make a representation. It will be disposed of in accordance with law.
Yes, my lord.
Lordship. And Lordship, prayer cannot be amended, but it is a settled decision of the Honorable Supreme Court that prayer can be altered, and due to that reason, in the last prayer we mentioned that pass such other order or further order. Lordship, when I have taken the averment in my writ petition, subject to Lordship's correction, I am saying it. When the averment has been taken in the writ petition, then it is put before the Honorable Court. Before the Honorable Court, that means within the notice of the Honorable Court.
We are hearing you.
So, Lordship, well, the vital thing is that one thing that in a RTI reply, Lordship, kindly come to page number 75, Lordship. In RTI reply, the concerned municipality clearly mentioned no common septic tank cannot be allowed. Common septic tank cannot be allowed for several owners. When it is not allowed, it cannot be allowed. So when it cannot be allowed, then the question is that how it is allowed by the concerned municipality. Several occasions, I made the representation to the concerned municipality, and the municipality did not take any action. But in the RTI, in the reply under Right to Information Act, municipality clearly informed that a common septic tank, common water reservoir cannot be allowed. And due to that reason, Lordship, in that event, enunciation of preface is highly desirable. Lordship, we had a common water reservoir. Due to that reason, municipality separated our common water reservoir, and presently two brothers have separate water reservoirs. But regarding septic tank, the municipality is very much reluctant.
Anything further?
Lordship, this is my humble submission, Lordship.
Thank you. Thank you. A judgment and order dated June 16, 2016, whereby the appellant's writ petition being WP 16759-W of 2015 was disposed of comma, is under challenge in this appeal. Paragraph. The appellant oblique writ petitioner and the private respondent in the writ petition as well as in the appeal, comma, are brothers. Brothers না হলে এত লাভ হয় না। Stop. It appears that they received, comma, as gift, comma, a plot of land measuring about 2 kotha 7 chitaks, comma, with a building standing thereon, comma, from their mother, Maya Rani Shur, comma, in September, comma, 2003. Stop. Paragraph. Subsequently, the property was divided into municipal holdings 7 capital A, comma, 7 capital B and 7 capital C, comma, Rashtroguru Avenue, comma, Kolkata 28. Stop. The appellant oblique writ petitioner occupies premises numbers 7 capital A and B, 7A and 7B, while the private respondent is in occupation of 7 capital C. Paragraph. The two brothers shared a common septic tank. Stop. The appellant wanted to have a separate septic tank for himself. Stop. Accordingly, he made representations to the South Damdam municipality. Stop. Not having received any response, comma, he approached the learned single judge by filing the present writ petition. Paragraph. The learned judge disposed of the writ petition with the following observations. Page 84-85. Set out. Paragraph. Being aggrieved, the writ petitioner is before us by way of this appeal. Paragraph. Learned advocate for the appellant relies on a reply dated August 28, 2014, received by him from the office of the administrator of the said municipality in response to an application made under the RTI Act. So, কিভাবে শুরু করলাম প্যারাটা? Learned advocate relies on, ঠিক আছে, comma, which is at page 75 of the paper book. Stop. Relying on such document, he says that there cannot be one septic tank for 2 or more municipal holdings. Paragraph. Learned advocate for the municipality says that after the order of the learned single judge was passed, comma, and in terms of that order, comma, the municipality conducted due investigation and the Board of Councillors of the municipality have come to the unanimous decision that construction of separate septic tank connected with separate municipal drainage facilities for holding numbers 7A and 7B together and 7C taken as a separate unit will not be allowed. Stop. A copy of such decision dated July 28, 2022 has been produced before us. Stop. Let the same be retained with the records. Paragraph. In view of the aforesaid decision of the municipality, comma, the only remedy that the appellant has would be to challenge such decision in accordance with law before the appropriate forum if he is aggrieved by such decision. Stop. That decision furnishes him with a fresh cause of action, comma, if at all. Stop. Paragraph. Learned advocate for the appellant further says that in the writ petition, comma, at paragraph
8.
8, comma, the writ petitioner oblique appellant has clearly alleged that unauthorized construction has been made by the private respondent. Stop. However, comma, the learned single judge did not address that issue at all. Paragraph. We see that there is no prayer in the writ petition with regard to any alleged unauthorized construction. Stop. In the representation made to the municipality, which is annexure P4, which is at page 80 of the paper book, comma, also there is no whisper about any alleged unauthorized construction made by the private respondent.
And at page 70 is the inspection report given by the municipalities, where it has been stated that it is not an illegal construction. At page 78, my lord. The third point. I am reading it out, my lord. One toilet exists at mezzanine floor. A toilet measuring 200. Oh. Third point, my lord.
Further, comma, learned advocate for the private respondent draws our attention to an inspection report
Which was signed by the appellant also. 9/1/2015.
issued by the Office of the Councillors of South Damdam Municipality, bracket deco page 78 of the paper book, bracket closed. Stop. It appears from that report that after inspecting the toilet that exists at the mezzanine floor, which according to the appellant is an unauthorized construction, the authorities have not considered the same as unauthorized construction. Stop. Paragraph, be that as it may, if the appellant is of the view that the private respondent has made any other unauthorized construction, comma, he will be at liberty to make appropriate representation before the Board of Councillors of the concerned municipality. Stop. If any such representation is made, stop. The same will be disposed of by the Board of Councillors in accordance with law, comma, by a reasoned order, comma, after giving opportunity of hearing to the appellant as also the private respondent.
One indulgence, my
Lordship, in that event, may I be given one indulgence with the Lordship's permission?
What?
Lordship, in page number 78, that is the report, in point number 3, it is written that one toilet exists at mezzanine floor. The toilet measuring such and such was constructed on 1992 by Maya Shur, mother of both the parties. Maya Shur was died on May 2007. The toilet is attached with only a room at mezzanine floor, which is used by Ranjit Kumar Shur. As per partition deed, this portion exists in the side of Sri Ranjit Kumar Shur. So from this statement, it is not clear that whether this the toilet is authorized or not, whether this construction is present in sanction plan or not. Because in this statement, it is not said that it is illegal or legal. It is mentioned that the existence of toilet is there, but whether this is legal or illegal, it will be revealed by strength of sanction plan.
My lord, if this is the fact, the mother has gifted me knowingly that there is a illegal.
But by strength of this, the illegal construction cannot be converted into the legal construction.
The inspection report, comma, maybe although it has been signed also by the appellant, comma, does not say that the concerned toilet is not unauthorized.
Even it is either way, it was not been stated, my lord.
Is authorized or unauthorized? Is authorized or unauthorized? Stop. এটা অ্যাড করে তারপরে লিখবে যেটা বলেছিলাম, if the appellant is of the view, বলা হয়ে গেছে ওটা, that the private respondent has made any unauthorized construction, ওই representation to be disposed of by reasoned order after, হ্যাঁ ঠিক আছে, paragraph এই তো হয়ে গেল।
And Lordship, kindly make it a time bound order, Lordship. Kindly, Lordship.
Within ওই যেটা dispose করবে, within 8 weeks from the date of
There is no representation at this point pending.
From the date of receipt of the representation, comma, if any.
In regards to the illegal construction, if there is any.
If any. Paragraph.
Lordship is not audible, Lordship.
8 weeks, 8 weeks.
8 weeks. I am deeply obliged, Lordship. I am deeply obliged.
With the aforesaid observations, the appeal stands disposed of.
I am deeply obliged, Lordship. I am deeply obliged.
Very well. You recover fast. Recover fast and come for physical hearing.
Lordship. I don't know why from today I am feeling one abdominal pain. I don't know. I will go to the doctor's chamber today.
Yes, please.
I'm deeply obliged, and with your Lordship's permission, I'm leaving this courtroom virtually.
Yes. You know.
Next item.
Yes.
Yesterday we taken about the Monday, next one.
Next item, which item, Mr.?
57.
We just now did
59.
I'm sorry, 59.
You want it on Monday? You will be in difficulty. Very well. Monday 50 Monday করে দাও। চলো। 2টোর সময় বেহরামপুর, হ্যাঁ, আর হ্যাঁ, ওটা তো 5-10 মিনিট লাগবে, তারপর আছে তো। হ্যাঁ।
Thank you.
I am for the Banerjee. All is very well, but Advocate General is not yet back in town. Has he come back to India?
Yes, ma'am. I'm appearing for the state order.
He has come back.
Yes, ma'am.
He has joined court.
Yes, ma'am. Yes, sir.
Is he likely to come today? No.
No, but another matter is going on, my lord. Chief,
ये देखिए আমাকে অর্ডারটা দেখো লাস্ট দিনে আমাদের দেখো any progress
My lord, on the part of Baharampur municipality, my lord, we had provided the property tax details to the district magistrate, my lord. So there are some more queries. On 8/6/2023, we had provided report and information regarding those queries to the municipal affairs of Baharampur to the district magistrate, my lord. Still then, they haven't yet given any report from their end, my lord. Lastly, a reminder letter on 12th was sent. My lord, I am handing over a set of the progress what has been done, my lord.
no last we recorded that about rupees 11 crore is outstanding to you on account of area tax in respect of state government properties.
Yes. That is situated within Baharampur municipality, my lord.
Right. Learned Advocate General appears and says that relevant bills department-wise should be made over to the DM Murshidabad. Relevant bills have to be verified, and after following due process, the bills will be paid to the extent they are payable under the law. Did you carry out this exercise?
Right.
You have. Who are you?
I am for the writ petition respondent.
You have another copy.
My lord, I will be handing over.
না জজ সাহেবকে দেন আর একটা দুটো দিতে হবে ডিভিশন
You are addressing a division bench.
ডিভিশনে যার একটা কপি দাও
কাণ্ডজ্ঞান একেবারেই নাই।
Not pardon, my lord. I will be handing over in post.
Yes.
My lord, after that, they had got some queries, my lord.
Good.
This was the letter they sent to us, my lord.
Rent rates and taxes.
আমাদের পার্টটা দেখতে বলেছে অর্ডার আমাদের পার্টে বস বলেছে না
Have you responded to this letter? So let us assume for a fortnight what to do.
My lord, whatever, my lord, instructions I have, my lord,
To the state.
yes, my lord, for the state, that my lord, certain, my lord, demand has been raised on behalf of the municipality for payment of taxes, alleging non-payment of taxes for using buildings within the municipal area. Now, our instructions is this, that state budget, there is a component under the head rent, rates and taxes. Under that particular head, there is administrative allocation by the finance department, and respective amount has already been disbursed since the financial year 2021 till financial year 2023-24. My lord, for any additional demand to meet the demand of any concerned municipality, the concerned administrative department has to make correspondences with the finance department, and accordingly the finance department will consider for further budgetary allocation in the next financial year. Prima facie, this is the instructions, my lord.
But that hasn't been,
Sir, we are trying to help some retired employees.
My lord.
The state should come to their rescue.
My lord,
If the state raises excuses
my lord,
instead of coming to rescue,
my lord.
then what can the court do?
No, my lord,
Welfare state, you call yourself welfare state,
my lord, my lord,
welfare of the citizens.
my lord, subject to correction, state is ready to, my lord, within the law,
We
within
can
the
see the
periphery of law,
readiness.
my lord,
We can see the readiness. We'll record all this when it comes to recording the final order.
my
The
lord.
readiness we can see. Technicalities. All kinds of lame excuses. Anyway, we adjourn it for 2 weeks and let us see. Yeah. Issue. Read order dated April 27.
May I be pardoned, my lord? My lord,
Parted before this bench.
no, pardoned, my lord. I want
Yeah,
to say,
gotcha.
actually, my lord, on the same ground, there are several other matters going on before this, the single benches, my lord. On the same, the gratuity matters and all those matters. But since this matter is pending, and since a lot of money is, my lord, we cannot pay to them, my lord. That is the problem we are facing now.
My lord, I have,
Distinct 10.
yes. But I think deservedly.
Yes, yes.
My lord, I had been speaking to the finance secretary, my lord. Now there are budgetary provisions. My lord, the bills, if they've been raised, my lord, the different departments can sort it out. My lord, there's provision, my lord, for my lord, this funding.
So when do we list it again? Tell us.
পঞ্চায়েতে তো লোক কিছুই তো ইনস্ট্রাকশন দিতে পারছে না 2 weeks করে যাচ্ছে My lord, kindly keep it after 4th of July.
We'll keep it after 4th of July. Issue. Read order dated April 24, 2023. Paragraph. Learned advocate for the municipality says that
I thought results come আসছে Hello, kindly keep it after 9th, my lord, because that's the date of result. I don't know.
after 9th. Culum, learned advocate for the municipality, says that in compliance of the aforesaid order, comma, the relevant bills and statements pertaining to the dues on account of property taxes from the state government were made over to the district magistrate, Murshidabad. Stop. This was also recorded in a letter dated June 12, 2023, a copy whereof has been handed up to us. Stop. Let the same be retained with the records. Paragraph. Learned advocate for the municipality also draws our attention to a letter dated May 19, 2023, addressed by the district magistrate, Murshidabad, to the chairman of the municipality, raising certain queries. Stop. Such queries have been answered by the municipality by its letter dated June 8, 2023. Stop. Copies of the letters dated May 19, 2023 and June 8, 2023 be kept with the records. Paragraph. Learned Advocate General tells us that he has had discussions with the relevant officer in the administration. Stop. The officer is working on how much actually is due to the municipality from the government on account of area property tax in respect of government properties. Stop. Paragraph. Let this matter be listed again on July 12th at 2 p.m. Stop. We hope that by that time, meaningful progress would have been made in the matter.
My lord, to make it more seamless, my lord, what has been handed up to your lordship today, my lord, rather than me recovering it from the district magistrate, my lord, if 2 sets could be given to us.
Certainly, you just give it, certainly. Thank you.
Obliged.
এটা কি সব সেপারেট অর্ডার হচ্ছে? শিওর তো? ঠিক আছে। আর নেই কিছু? ওটা তো ভাই হিয়ারিংটা হয়েছিল অপূর্বদার বেঞ্চে, বেলটা সেদিন তো হিয়ারিং হয়েই গিয়েছিল। হ্যাঁ হ্যাঁ, বাহ, আমি রেকর্ড করেছি অর্ডারে, দেখো ফাইলটা বার করো। হ্যাঁ